Today's video is what are my enforcement options? You've gained a CCJ, a county court judgment, and the debtor is still not paid despite being ordered to do so by the court. What are your options? Option number one, send in the bailiffs. You actually have two options here. You can either use the county court bailiffs or you can use a high court enforcement officer. And what is the difference between them? Well, county court bailiffs are salaried civil servants who work directly as employees for the local county court. They're usually quite busy and their average time to report back to conclusion is around 60 days. They work restricted hours, morning till afternoons, Monday to Friday only. They cost around £110 to instruct. Or you can use a high court enforcement officer who sends out private enforcement agents to collect your money. Their average time to report back to conclusion is around 30 days. They work between 6 in the morning and 9 at night, 7 days a week. If they're successful, their service is totally free, as all fees, whilst charged to you, are recoverable from the debtor where possible. If uncollectible, all you'll have to pay is the compliance fee of £75 plus VAT. The only other fee you need to pay, but again this is recoverable from the debtor, is the court transfer fee of £66. The bailiffs charge their fees to the debtor, but they only get paid their fees if they recover your money, so they're as invested in getting your money as you are. Option number two, order to attend court for questioning, known as an N39. Sometimes you would need further financial information about a debtor in order to decide what course of enforcement suits your case best. This might be things like what money the debtor holds in their bank accounts, how many accounts they have, what they earn, what assets they own, where they work, or how much they owe on a mortgage. The court issue this N39, but it needs to be served personally upon the debtor and an affidavit filed with the court thereafter. This can be done by the court bailiff, but in our experience it's better to use a professional process server. If you don't know a professional process server, we can recommend one from our panel of process servers. If the debtor does not turn up at the hearing, the court may decide to send the debtor to prison. Option number three, an attachment of earnings. If you know the debtor is working and you know who their employer is, then it may be an option to issue an attachment of earnings. This would be where the employer is compelled by a court order to deduct an amount from them each time they're paid. Sometimes just writing to the debtor and explaining to them this is going to be your next step is enough to get them to pay up quick, as they don't want their employer to find out. Option number four, charging order. If your debtor owns their property, then you can get a charge put on it. This is so that if the debtor tries to sell or remortgage it, they have to pay off the charges in order of priority first, and you would obviously get your money provided there is equity in the property. You could either wait for that to happen, or you could try and get the court to enforce an order for sale. But again, sometimes writing to the debtor and explaining to them that this may be your next step is enough to get them to pay up quick, as they don't want to lose their house. Option number five, a third-party debt order. This is an order that allows a creditor to serve upon a person or an organisation, for instance a bank, who is holding money that is owed to the debtor. It then forces them to pay this money to you instead of the debtor. Can work well if a debtor has money in their bank account, or if a tradesman and they're owed money by another company. They then have to pay you instead. Option number six, insolvency proceedings. As long as the debtor owes the current limit, which is £750 for limited companies and £5,000 for individuals, you can use the Insolvency Act to either make someone bankrupt or issue a winding up petition against a company. Thanks for listening.